Adjournment request, if any, from item number 1 to 5. From
in item number 5, well, my officer he was out of station. Well, now they're just coming with the affidavit. Affidavit in operation. I could file the affidavit today. Well, during course of the day, I will file.
That RUB matter. RUB matter.
RUB matter. RUB matter. My officer was out of station. I could not. Although I pay for 3 days time earlier. Today he is coming.
Friday.
Friday, Lord.
At the request of Council President Dina. This one Friday. Friday.
adjournment request from item number 6 to 13.
Please, the other side, I beg to mention item number 9, matter not posted after a week.
Yeah.
After a week.
What do you want?
Adjournment for the day.
On last occasion also you sought time.
Lordship, Mr. RKD Chaudhary is out of station, Lordship. So
Who is out of sanction?
Mr. RKD Chaudhary is appearing in this matter is out of station, Lordship.
You have to submit the report. Like what you have done to the guidelines of the central government.
Lordship, that can be submitted today. The report can be submitted today.
Report is already submitted. You are in this
No.
of that.
No, Lordship, I will submit it today.
So they are about to submit it
about to
through
submit
an affidavit.
Yeah, that's right. You were supposed to file an affidavit in that regard.
Lordship, 1 week, Lord.
Then your lordship may fix the matter immediately after the vacation.
22nd July.
Highly.
Well, this is a long pending.
23rd.
No issues, your lordship. However, this is a long pending matter.
Yeah, that's right.
How less?
Yes.
May please, Lord, I beg to mention item number 7, my lord.
Yeah.
Here we have the instruction to not to press with the matter, my lord.
Okay.
Item number
Says not pressed. Item number 7.
7.
These are the, what about these connected matters?
Item number 6, your lordship.
Yeah.
Our counsel is out of station. So
He has already withdrawn the petition challenging this same, then what remains in this now? I think so the grievance must have been redressed by now.
no, your lordship. State Act, new act has been enacted.
Yeah.
So that thing will be taken up by our senior counsel.
After this, you have challenged the validity of this which act in these petitions.
Lordship.
So after that, new act has already enacted.
Your lordship.
Then what remains in this petition, if you are having any grievance with the new act, challenge that.
Your lordship, the act is still in force. The old act is still in force and a new act has been subsequently. The fees, they have another new act has been framed.
You have not challenged validity of that.
Your lordship, this is pending, so we haven't challenged.
The number comes 50.
Lordship.
May I please, Your Lordship? My lord, I am seeking adjournment for item number 20, my lord.
0.
20, my lord. Kindly pass over for the day, my lord.
Hearing matter, then it will go. After summer vacation. After summer vacation.
Only for the day, my lord.
Summer vacation. After summer.
May I please, Lordship? With the concern of arrest, I beg to mention item number 17, Lordship. In
Yeah.
this case, we are led by Learned Senior Class PT Goswami. He is in indisposed, Lordship, due to eye surgery. Lordship may have the matter after summer week.
Who is for the other side?
I have.
Summer vacation.
Obliged.
May I please, your lordship?
A date may kindly fix if possible.
After summer vacation, you get the date from registry.
May I please, your lordship? Also, I beg to mention item 12. We have taken consent of the other side, respondent 2 and 3 in this matter, your lordship. Matter may come up after vacation, your lordship.
If you have taken the consent, what
Yes.
we have to pass, you just suggest us, we pass the order.
Yes.
If the both the parties are in agreement.
Here was problem. Here was problem. Here was problem.
You should take consensus on what order should be passed. You supply us, then pass an order.
Your Lordship, we could not prepare the matter, so we need adjournment in this matter.
Yeah,
That is fine.
Lordship, a date may be fixed in this matter.
After summer vacation, you get the date.
Yes. Obliged.
Deeply obliged.
Please, your lordship, but I would beg to mention item number 19, my
19.
instead of hearing, my lord. Due to some personal difficulty, my lord, my senior couldn't prepare for the matter today, my lord, my kindly pass over the matter for the day.
We are not supposed to ask what personal difficulty, but it's middle of 2022.
Yeah.
The hearing list was circulated well in advance.
My lord,
You should have prepared it, the hearing matter.
my lord, he was not well, my lord, that is why. My lord. Just a week.
After summer vacation, check. Yes,
May I please, your lordship, with the consent of other side, I would like to mention item number 16. It may be listed after summer vacation.
Yeah.
Obliged.
yes.
May please, your lordship. I paid for listing and rate appeal and tomorrow, your lordship. It is filed on last
Was the
Friday.
urgency?
Urgency that London single just set aside my LPG distributorship. LPG distribution, it is running by the appellant of last 5 years. It is set aside by the Langan single. The challenge is that I have filed a rate appeal. And the ISL also
Friday. Friday.
published.
Daily list for orders, item 1.
But in this case, I have received the report. But because of some disturbance, I would say, they are not in a position to progress with the work since 22nd of May. But what has happened, my lord? The length of the road is 90 meter, my lord. And out of 90 meters, 65 meter they have already done. In respect of the rest of the portion, my lord, at the bottom, my lord, at the lower side, my lord, they have been the local omen, they are not allowing the contractor to perform the work, citing the reason that the particular person in front of whom whose house the road is to be constructed, he is encroaching some land. In fact, the width of the land at the upper portion is 4.5 meter, and the lower portion is little bit 3.2 meter. The area is 3.2 meter. They are demanding that the road should be 4.5 meter. Otherwise, they will not allow to go ahead with the work.
We, on the last occasion, we asked you to supply the names of persons who are obstructing the construction of the road. And also,
Kindly see, there in the instruction itself, they have also requested the registered admin, the page 3, kindly see,
page 3,
page 3, the last page.
who is requested?
The executive engineer, registered admin, they have requested that kindly held a meeting with the person, because the local resident here before the honorable court, they have given an undertaking that they will allow us to execute the work. Now at the place, according to my instruction, 3.2 meter is available. It is also sufficient, 3.2, they are not allowing. They said that you do the construction keeping the road width 4.5 meter.
Is there encroachment over the road?
No, they said that is their patalan, and the circle officer, they have seen it is some patalan is there. Although their boundary wall is,
That's why only Mr. Last occasion, what order we have passed?
but
Have you gone through that order?
I have seen.
What was that order? Why have you not supplied the name of those persons who are obstructing?
But
Why you have not supplied the name of those persons? We asked you specifically.
I'll
No, what I will then, what's the use of passing this order?
but it is not, the names are not available because
Why the names are not
public,
available?
public-
Now you are saying some people are, who are those persons?
the local residents, they claim that
So local residents, there must be some identity of those local residents.
whatever is available, I'll tell them to give.
This is
The
not the
omen,
way you are-
the group of omen, they came, they are coming. I'll
Whatever may be,
I'll tell them.
please supply the name of those persons.
Lodge.
But why you are hiding and giving these names? It
I'll-
seems
I'll-
then you are not interested in getting this work done.
But
Ultimately, it's a building belonging to the judicial, this infrastructure.
correct, my lord, correct.
And the alternate road is supposed to built by the administration way back.
True,
And now you are showing your excuses. That's why only last time we have asked you, supply the name of those persons who are expecting
Lordship, I'll provide, my lord, I'll give them, my lord, I'll,
by tomorrow.
by tomorrow. I'll give them.
Okay. Mr. Deena, and it's senior advocate. Government advocate Assam,
Manu,
Please. a day's time to comply with the order dated 27/5/2024 passed by this court. Just tomorrow. Response to answer.
For admission, item 2.
May I please, Lord? This is really directed against the order dated 19/11/18, my lord. Wherein the single judge is directed to comply with the MOU. That is really
You're supposed to comply with the MOU.
and
Then why you have executed this, entered into a MOU with this?
entered into MOU, but there is a clause in the clause number 5, my lord. That the finance will be managed by the, if lordship turns to the MOU, my lord,
What
it's
is
page
that?
number 40. Finance part will be supplemented by the, will be in the burden by the BTC. But finance is the subject which has not been entrusted with the BTC, my lord.
40.
40, my lord. Clause number 4. And this finance will be supported by the BTC and it will not be a burden to the state of Assam. But finance is not an entrusted subject of the BTC, Bodoland Territorial Council, my lord. There it had, in fact, on the day of the execution of this deed, my lord, ab initio it is void, my lord. And this agreement, my lord,
Who is the third party?
third party is the NTPC. That NTPC will be,
The memorandum of understanding from.
first is the government of Assam, second is the BTC, third is the
Fourth party
NTP.
is the principal secretary, Borowan, Sukraja, second party. So this building is constructed by the NTPC.
NTCPC.
They have already constructed.
They have already considered these persons have been inducted. Only thing is that the finance part of the bearing that salary had to be.
Finance part,
Finance means
regarding-
bearing the salaries. Salaries of these persons, 8 persons had to be borne by the BTC. And
After
BTC,
the construction of the IT was completed, by the third party, that is
that is the NTPC.
NTPC. The same shall be handed over to the second party, you.
That's it.
The second party shall appoint, engage instructors and other staff as per the norms and shall bear all the recurring expenses as a payment of salary and other administrative expense. For running the institute, there is no financial implication on the first party
That is
in
the state
terms
of
of the creation of the post of the maintenance of the institute.
Lordship. And this agreement is, in clause number 16, my lord, this agreement is
So,
valid.
so whatever this finance party is concerned, you were supposed to.
Yes, you are supposed to do, but the finance is not a subject of the entrusted subject of the PTC council, my lord. Finance is the
Then why
state
you entered into all
of,
this?
that ab initio it was void, my lord. That
Yeah,
ab initio in the day of entering into it was void, my lord.
have you ever challenged this MOU?
No, this had not been challenged because there is a, in page number 42, my lord, there is a clause, my lord. Clause number 16, because if there is a something, I'm allowed to read to this, that in case need arises, the parties to the MOU shall amicably decide either to renew the or to enter into fresh MOU on mutually agreed terms of the condition after 5 years of the date of execution of the MOU.
This MOU is of year 2017.
My lord,
That 5 years have already
my
passed.
lord, 5 years passed. And in the on the date of delivering the order itself, the 5 years has passed, my lord.
Whatever it may be,
Thereafter, my
then
lord,
why you have not pointed it out
on that,
before
my
the
lord,
learned single judge?
Lordship, my lord, in fact, my lord, there are review petition been filed. A review petition had been not yet entered in because that there is a lapse of that particular period, my lord. And there was a communication between the government, BTC and the government of Assam to mutually agree and find out a solution, my lord. And that had not been ultimately, even the new agreement was sent to the government of Assam, that had not bring any fruit, my lord. Therefore, there will, in the meantime, we have filed the appeal and there is a delay.
Then no, this can't be the excuse. This can't be the excuse, sir. Once you have entered into the MOU, now you are saying that this is what we are facing the problem. This MOU is why did initio? What is this? Why you not raised any concern about this MOU?
Well, in the meantime,
No.
fresh MOU was sent, my lord, that was not been
This can't
executed
be this can't be the excuse.
because finance is not a subject matter of the BTC.
Whatever it may, then why you have entered into the MOU?
Well, that's the initial, that particular point of time, well, that was not.
That particular point of time, then what action you have taken against the person who has entered into that MOU?
No, only
Now
thing,
you can't wriggle out this MOU.
only thing is that
No,
we have
this
sent a
is- this
fresh
is
MOU to the
absolutely
state of Assam, my lord, to
unacceptable, sir.
consider, my lord. Fresh MOU was sent to the consider that was not considered.
Whatever it may be, you do whatever you want. But ultimately, we don't find any illegality with this order.
Yeah.
The MOU was there, it was never decided. You have to act upon this.
Yeah.
Before the learned single judge, you have not said, where is your reply to the petition that this MOU is void ab initio? What is
No, no.
that? Have you filed any reply to this counter to the petition?
No, there is no reply, my lord, there have not been
Then
filed.
now you are coming with a altogether new plea which you have not even raised before the learned single judge. And what about your review?
Review has been dismissed on the ground that there is a fresh application in to the state of Assam and that period is 6 years.
Where is that review order?
Lordship will starts from page number 96. 11% is in page number 102, last paragraph, my lord. Paragraph number 14.
Absolutely, Leonard Singhal dealt with everything in the review order. These are these can't be the grounds for that. Why we have entered into this agreement with the,
Finance was not within the subject matter,
then you should have taken this plea at the time of this entering into MOU.
Right.
That can't be done.
because in the meantime, that lapse has taken place and we have filed a sent us a review MOU, what has not been entered.
Anything else?
Oh, that's enough.
Writ of appeal is filed by the FNR. Challenging the order dated
9/11/18.
9/11/2018 passed by the Leonard Singhal judge. In writ petition number 1812/2018. The respondent the respondent number 125 herein has filed a writ petition number 1812/2018 before this court with a prayer to give a direction to the respondent authorities to implement the order dated 20th of February 2017 by which the state of Assam had approved creation of 28 members of posts in bracket gazetted and non-gazetted bracket clause category for IIT Salaketi. Stop. The but respondent number so and so here has also relied upon a memorandum, a MOU with tripartite MOU executed between the state, the appellant BTC, and the NTPC dated 12/7/2011. Wherein the three parties to the MOU has agreed on certain points regarding setting up of a ITI. Full stop. As per the said agreement, the the appellant BTC is required to bear the recurring expenses such as payment of salary and other administrative expenses for running the institute with a clear understanding that there shall not be any financial implication on the part of the state government. Full stop. The learned single judge, taking note of the above fact, particularly taking into consideration the terms of agreement of the MOU, has disposed of the writ petition with the direction to the respondents, particularly to the respondents of the writ petition, particularly to the appellant BTC, to implement and execute the government order dated 20th of February 2017, passed in terms of the memorandum of understanding arrived at between the parties on 12/7/2011, within a period of 6 months from the passing of the order. Stop. It appears that being agreed with the order dated 9/11/2018, the appellants has preferred a review petition before the learned single judge. However, they said review petition number 96 of the 2019 came to be dismissed by the learned single judge on 12/3/2020. Full stop. In the review petition, the appellants has taken a ground that the BTC is not able to act in accordance with the MOU and the government's order dated 20th of February 2017. Due to the financial constraints faced by the BTC, is specifically contended that the finance subject is not entrusted to the BTC, and therefore the BTC cannot bear the expenses such as payment of salary and other administrative expenses for running the ITI in question. Full stop. The learned single judge dealing with the said argument of the appellants raised in the review petition has specifically observed that if the BTC if the finance subject is not entrusted to the BTC, how the BTC has entered into the MOU with the state as well as the NTTC, and that cannot be a ground to review to review the order passed by passed in writ petition number 1812/2018. A similar ground is raised by the appellant, by the counsel for the appellant in this appeal, insisting that since the finance subject is not entrusted to the BTC, the recurring expenses such as payment of salary and other administrative expenses cannot be borne by the appellant BTC. Having heard the learned counsel for the appellant, we are of the view that in the MOU dated 12/7/2011, the BTC has agreed for bearing the recurring expenses of the IIT in question. Supposedly, while knowing that the finance subject is not entrusted to it, stop. Once the MOU is signed by the BTC, it is not open for the BTC to wriggle out of that MOU by making excuses which certainly are very well known to it at the time of signing the MOU. Stop. Keeping in view the above facts and circumstances of the case, we are of the view that no case for interference is made out in the impugned judgment, hence the appeal is dismissed. IA number so and so is also disposed of. This IA connected, IA number connected to this writ appeal na? IA number 1872/2024 is also disposed. Yes.
Item 3.
May I please, Lordship? On the last occasion, notice had been issued to state respondents. So, Learned Counsel for secondary was supposed to file reply.
Is the concept of the state? Yes.
I would like to file a affidavit of this. 2 weeks, 2 weeks time will be granted to us, Your Lordship.
Okay, so for you are for Mr. Majumdar.
Yes, Your Lordship.
Mr. Majumdar. SC education. Please some more time to file reply to the time frame for a grant list of which.
Obliged, Lordship.
Item 4.
My pleasure, Lordship. My lord, this petition is being filed, my lord, with a very limited prayer, my lord. Of course, where the borrower, my lord, there was some lapse on our part in not returning the loan amounts. Then proceeding was initiated before the tribunal. And we also filed, my lord, essay against the, my lord, NPA. But wait, maybe, my lord, now the way of which they have filed, that is pending before the tribunal. In the meantime, my lord,
They have filed away for what?
for recovery of their, my lord, loan amount.
Yeah.
And in the meantime, my lord, they opted to go for other proceeding under the Surface Act, NP Act. And in the meantime, my lord, they conducted the sale, auction sale, and land was, according to them, was sold. My lord, there was no OTS process initiated by the bank. We made an offer and we agreed to pay 45 lakhs. They, my lord, sent the matter to head office Bombay. And head office on the next day, my lord, intimated that amount is too low. We expected that, my lord, some more offer would become from their part, on their part, my lord, so that we may repay the loan amount. Now they, my lord, sold the property, my lord, at rupees 52.60 lakhs. And we are ready to pay the said amount, my lord. Subject to, my lord.
Ready to pay the said amount, it is for the bank to accept the amount from whom? How this court can issue a direction?
My lord,
accept from him?
That's right, my lord. My lord, on some humanitarian ground, my lord, since only our.
In these financial matters, no humanitarian ground, the Supreme Court has deprecated this practice several times and recently also.
My lord, we are ready to pay, my lord, whatever amount.
Maybe you are ready to pay, approach the respondent bank. If they are agreeing, then it's okay. Otherwise, we are now, this court has nothing to do in this matter.
My lord, Lordship kindly appreciate one thing, my lord.
Yeah.
But, my lord, for a moment. They initiated proceeding under, my lord, another act, that is the GRT. And proceeding is pending. Without any intimation in terms of section 19 of the, my lord, Bankrupt and Recovery Act 1993.
Yeah.
There is a specific provision under proviso that without the leave of the court or tribunal, you cannot initiate a fresh proceeding under any other act.
Do you raise this point before?
We raised this question, my lord.
In the writ of in the OA or the application which they have filed before the tribunal.
We have been asked, we are directed to submit our reply. We submitted our reply and matter is pending. In the meantime, without any intimation, my lord, they initiated fresh proceeding. And therefore, my
What is
lord,
the
they,
authority of this court to direct the state bank or the bank
my
concerned
lord,
to accept your offer? Which law permits? You show us the law, we'll pass in order.
my lord, Lordship kindly appreciate that, my lord. Reserve Bank of India initiated a policy
Yeah.
directing all the banks to, my lord, to initiate OTS.
Yes,
And once OTS was, my lord, initiated, then it should have come.
you show us the law. Sir. Show us the law that while exercising power under Article 226, we
My
can
lord.
issue such type of direction, we'll issue the direction.
My lord, at least one decision we can refer to, my lord, that was by Kerala High Court. Kerala High Court, my lord, has set aside the entire proceeding and granted a stay,
That may be
directing the bank to give them opportunity to refund the loan amount.
When this judgment was passed.
That was the judgment, my lord. 2022.
2024 judgment is there.
Hmm.
The three-bench judgment of the Honorable Supreme Court had deprecated this practice. in
Yes,
so
my lord,
many-
that I have gone through, my lord.
So
Deprecated.
Then what's the point in arguing?
Then, my lord, once we are ready to pay, bank should have some, my lord,
So
taken
that is
some
not the
reverse.
bank. You just show us any law where the borrower is ready to pay the amount and the bank is not accepting, we can issue amendments to them that accept it. Show us the law, we'll pass an order.
Then, my lord,
Otherwise-
Then, my lord, Lordship, kindly give me 2 days time.
Okay, fine. This one,
Find out decisions.
Friday.
The matter is, matter is fixed on 25th before the DRT for final hearing, the surface application.
When?
25th of this month.
So,
Friday also is fixed to matter, Friday.
Friday.
Well, I will try to, my lord, find out some decision.
It's very difficult, but you please try.
I know, my lord, is difficult. Even then, my lord, and we appreciate, my lord, all emotion, sentiment, everything is attached, my lord. It is our residential, my
The
lord.
courts can't run by the sentiments, sir. We have to go by law. Ultimately, it's public money. It's not.
Yes, my lord.
You're in our money.
Young entrepreneur, they took some loan, my lord, in the meantime, pandemic, they could not, my lord, run their business, huge loss.
Everything is there, sir. Everything is there, but ultimately, the court is, the Supreme Court is specifically. said,
Supreme Court deprecated.
Don't interfere in these matters.
My lord, Supreme Court deprecated. But there are some gray area, where lordship can interfere. Because the OTS is a process, my lord, it is nothing but an administrative decision of the bank,
Okay, on Friday.
my lord.
For hearing. Item 6 to 8.
May I plead your lordship?
Yeah.
Our engaged counsel is out of station.
So after this, Assam Non-Government Educational Regulation and Management Act 2006, is there any new enactment?
New enactment.
There are subsequent amendments are there.
Amendments are there.
Amendments. Act is still in force.
Okay, the act is still in force. They have checked the validity of this.
Yes, Lordship.
But I think so, similar petitions have already been disposed of, or some directions are issued by various high courts as well as the Supreme Court also.
Here also 2-3 times full length hearing took place
Yeah,
in these cases.
in one of the cases, he has already withdrawn that Delhi Public.
That is regarding one school. This is Association of Schools petitioner.
So what do you want now?
Adjournment for today. He is out of station. On the next day, he will be available.
After vacation, let it,
After
after vacation.
Start.
Deeply
The
obliged.
request of so and so, list after vacation.
Obliged.
Yes, 7 is already disposed of 6 and 8.
Item number 10.
Senior counsel, Mr. K. N. Chaudhary is on legs. He will be arguing the matter. He was here, he just left.
Many times and since many PALs have already been disposed of, what remains in this?
No, on the ground of res judicata, there is some issues there. He's on legs, he will be arguing the matter.
After summary action. Nothing.
Obliged.
Item 11.
Yeah.
And your lordship may kindly see order dated 8/8/23.
8/8/23.
Yes.
Yeah.
On perusal of the evaluation sheets, we find that there have been rampant cuttings and overwritings in the manner of awarding marks to the candidates. There are various other discrepancies which for the present we refrain from commenting upon, since the criminal case in relation to this election in question is still under pending. Representing the appellant and the private respondents are allowed to peruse the record. Postal copies of the record shall be provided. Now 23/8/23 order.
Yeah.
Lordship. Now, this is in connection, my lord, selection process initiated in the year 2012 for district malaria officer. After that, my lord, written test was there. They have not taken into consideration the marks in the written test. Before the Viva voice, my lord, there was a telephone call by one Mofidul Islam, who has been charged sheeted in connection with similar matter in another case. The records I have produced. And the interview was taken by one, my lord, Basanta Dole. And another person, my lord, he is also charged sheeted in another case. So ultimately, what my task will be, the selection process, my lord, which was initiated, my lord, they did not take into consideration the written test marks, which they are saying that this is.
That the learning thing is dealt with.
Yes,
That's why only the.
Therefore, the record was.
distinguished.
Therefore, the record was called for, and the record shows, my lord, there is manipulation of marks.
But if the law permits to select those persons only on the basis of Viva voce.
Yes.
And no requirement of consideration of the written test, what to do?
No, I'm not there, my lord. On the basis of the records, my lord, if the record shows, the record has shown, my lord, I have also shown the judgment. Order dated 8/8/23, your lordship has seen the record. Record shows rampant cuttings of marks and manipulation of marks.
But I think.
So therefore, the matter has to be decided by the APSC afresh. It has to be
APSC?
decided,
APC?
APSC selection, yes, Assam Public Service Commission.
They have not taken into consideration those answer sheets for the purpose of selecting.
No,
those
that is all,
persons.
answer sheet similar to what the court said, Lord Singh said, selection on the basis of the viva voice, there is nothing wrong in it.
Yeah.
So that is all right, I'm not on that.
That-
But thereafter, my lord, division bench, this court, my lord, call for the record. And on the,
Ultimately, we understand that.
yes,
But even though if the record is called
yes,
and the marks were not awarded or the persons were not selected on the basis of this written examinations, what would the impact
no,
of
no,
these?
viva voice test, on the basis of the viva voice test, they have selected them, and the viva voice test, my lord, there is manipulation, markings in the,
Why
my lord,
was a test then? Where is that?
that is the record that I have shown, 8/8/23.
In the answer sheets of the written examination, not.
No, not that. Viva voice test. APSC is there, my lord, I think, and they have given a chart, my lord, 23/8/23, which your lordship has kept it in seal cover. So my, additional evidence, marks, pagination of photo. This is in the period when Mr. Paul was there.
Your interview was held on which date?
It was held on, I think 18/9, 15.
Yes. He's appearing for the APSC in state.
So I am appealing for Assam Public Service Commission, Lordship.
What?
Assam Public APSC, Lordship.
What do you want to say?
Lordship, in this case, by in pursuance of the order of the Honorable Court, we have produced the record, and record was furnished to our landed additional advocate general for perusing and submit a report, Lordship. They have prepared a report, Lordship. We also, Lordship, asked to submit if anything to say, Lordship.
You also?
We also asked to submit by this Honorable Court, Lordship.
Then
So-
for whom are you waiting?
Lordship, I also prepared one, Lordship, mark, Lordship, tabulation. I want just to please.
This report is by whom?
This report by Advocate General.
Report is with the election agency matter. On the Chief Justice, Vivian on Tuesday directed me in my individual capacity to peruse the record and prepare a report. We have prepared a separate.
This one report is to be by you.
Ma'am. Based on the mark sheet and the mark shown in the merit list.
Lordship, based on the same mark sheet, Lordship, I also, Lordship, with the help of the office of the APSC, has prepared a report, Lordship. Kindly first go to the flag mark portion first, Lordship.
Yeah.
Lordship, this is the comparative merit come selected for recommended, Lordship. Lordship, for example, in CL number 1, Naina Bhuya, Lordship, in column, Lordship, original mark, she was shown as 82, but in the merit list, she was awarded 80 mark only. Thereby deduction of 2 mark, Lordship. Still, she got recommended. In same case, Lordship, up to CL number 4, Raju Shetty, Lordship. But if Lordship come to the CL number 11, one is Mejadul Islam, Lordship, who is the respondent number 6, who was the recommended candidate. His original mark was, Lordship, 74. There was an enhancement of 3 marks and it was came to 77. It was by the chairman Rakesh Kumar Pal. He was recommended, but he would have been out, Lordship. He could not have been recommended, Lordship. In this, that way, Lordship, CL number 19, Lordship, Jyoti Shikha Das, Lordship, she was 71. By this marks, Lordship, she was also not to be recommended, but she was recommended, Lordship. She would have been out, Lordship. CL number 21, Gitartho Kumar, Lordship. Original mark was 71. There was a reduction. Still, she was recommended, but she would not have been recommended, Lordship. In it's 25, Lordship, Karen Beapi, by mark 70, Lordship, she was selected, but she would not have fine place in the list, Lordship.
Now you zero down all this.
Now zero down, Lordship, first page, Lordship.
Yes.
This is the, Lordship. If that there would be no alteration as per the original mark, this should have been the, Lordship, original select list, Lordship. In first, Naina Bhuya and Harshajyoti Majumdar, their position would have been same. The Jyoti Prasad Lahan, Lordship, she was awarded in 9th position, Lordship, but she would have been placed in the 3rd category as an open category, Lordship, if there would be no reduction. Likewise, Lordship, Raju Shetty, he was not selected. If his mark was not reduced by 7 marks by the Lordship member of APSC, the then member, he would have been selected, but he was deprived.
So now what do you propose?
Lordship, I am placing before Lordship.
You have carried out your exercise and there are illegalities or whatever you can say. Now what the state government is proposing?
Lordship, the state government has not appointed those candidates, Lordship.
Appointed the state government, recommended by the APSC, appointed by the state government.
Lordship, there was a
Appointed, so what do you mean by not appointed?
Lordship, there was a recommendation after going to these marks and after this exercise.
There was illegalities in the recommendations.
Yes,
Now
Lordship.
what the state government is proposing? Yes.
Once the Honorable Court decides and
Thereafter,
So decides here the rampant illegality or irregularities are here.
my lord,
Now what the state government's stand is?
the stand is, my lord, now this matter is pending before, Lordship. We have Lordship directly will appoint. We have got, they are the selecting agency. Once the selection,
The selecting agency, ultimately you are the appointing,
True.
you have appointed those persons.
no, they were not,
APSC is the-
they have not been appointed, man. That is,
Huh?
that, they have not been appointed. That is what I am saying.
They have not been.
No,
appointed. Nobody is.
no,
appointed. Is there was any stay? Why they have not?
Before this largest single judge, there was a stay. Before the division bench, there was no stay, but they filed a writ petition again for the purpose of implementing the order passed by the High Court. So that writ petition is also pending. There was a direction for appointing them. We filed a review, that matter is pending. So now what my submission is, my lord,
No appointments have been.
no appointments have been made. My lord, what I find, my lord, subject to what your lordship may say, this was an advertisement in the year 2012 for the post of 14 posts. Record shows, my lord, is a tainted, my lord, the whole process is tainted. So therefore, my submission would be, they will have to redo the interview or redo the, my lord, fresh advertisement, giving chance to all the candidates for, and this is what, secondly,
In the year 2012.
yes, my lord, this is what, otherwise they will have to re-advertise it. My lord, another aspect besides this, my lord. And besides this, my lord, besides the marks, all these things, the person who has taken interview, my lord, he is also a tainted person, my lord. He has been arrested and charge sheeted in connection with similar matter in another case, which I have shown in my additional affidavit. This is during the time when Mr. Pal was the chairman of the APC. On the face of it, my lord, this whole process has been bargained and the marks have been allotted to the candidates. So therefore, my lord, in the circumstances, since the appointments have not been made, 2012 advertisement, fresh advertisement giving chance to all persons, irrespective of their age, to appear or redo the interview. An interview is also, the marking is, my lord, without any scientific basis, which is required. If it is only on the basis of interview.
Is there any amendment in the rules to that?
No, no.
Still the.
Yes, my lord, from the records, what I find, my lord, last time when I saw 50% marks on the basis of educational qualification, 20 on the technical, 30 on the interview. 20 on the technical, my lord, there is no issue because there is no erasing of marks and all. 30 marks on the basis of the interview, and interview held by Mr. Basant Dole. And very Basant Dole, he has been charge sheeted in similar case and all. And person who has given a call to the petitioner.
Yeah, what do you want to say? On behalf of the selected candidate. Huh?
Provincialization method.
You should have made it early. You should have asked the court earlier. You should not have devoted a time in this matter. This is not the way. Once the matter is, we are in the midst of the argument for half an hour, and now you are making a request for adjournment. That is not correct, sir. After some time, what do you mean by after some time? What is this?
Redo the interview. Who did you call? Okay.
it's ready.
Can only give us a cup of.
Who is appearing for the selected candidate? And two. And what are the number of those petitions which are pending on behalf of the selected candidates? Review petition of this judgment?
Well, during the pendency of the case, they filed a writ petition before a single judge.
Yeah.
For the purpose of implementation of the order passed earlier.
Yeah.
So there, my lord, and-
Passed in this petition,
no,
passed in
earlier
this-
single bench.
passed by the single judge.
Yes.
They have moved another writ petition.
During the pendency of the writ appeal for the purpose of their appointment.
Yeah, then
So there, my lord, they, without hearing us, without giving notice to us, the learned single judge has passed an order for appointing them.
Fine.
So there we have filed a review petition. The review petition has not been decided as yet. The matter is pending.
review petition is pending before the learned single judge.
Single. Honorable Justice Manas Pathak. For last 1.5 years. Okay. Pending.
That has already been heard.
It was hard on several occasions, no order has been passed. And that your lordship may, lordship may call for. I can give them. My lord, this writ appeal is decided, my lord, it will take care of whole thing. Those who will become infected.
Ask Mr. Chaudhary to come. At two.
12 years gone by. 12 years gone by.
Yeah.
12 years gone by, man.
Since the advertisement.
Since the advertisement.
Lordship, one thing I just proposed, Lordship, if Lordship or permit Lordship. But in earlier occasion, Lordship Director also expressed his mind, Lordship, my Lord Justice, Lordship.
By?
Lordship Director, Lordship Mehta also expressed his mind, Lordship, that APHU would be directed to conduct a fresh interview on the basis of the same list of candidates by setting aside the present select list, Lordship, so that none could be deprived of the view considered as another advertisement. And if that direction is passed, Lordship, we are ready to conduct a fresh interview in terms of advertisement.
What option would you have then? If we issue a direction, you have to comply with. We are ready to, what do you mean by we are ready? You have to
Comply.
comply with it. Yes.
At 2 o'clock.
Item 13.
May I please, Lord? My lord, this appeal is directed against the judgment, informed judgment passed by the learned single judge, Lordship. The fact of the case is this, Lordship. The present appellant, Lordship, is a SSI unit duly registered under the provisions of the interest on delay, this MSME Act, Lordship. And the appellant, Lordship, has supplied still material to the respondent writ petitioner, Lordship. So there were some dues for which, Lordship, a money suit was filed. That money suit was dismissed, against which RFA was filed, which was also dismissed. But fact of the case is this, Lordship, in the meantime, the Interest on Delayed Payment Act had come into force with effect from 23rd of September 1992, Lordship. एक हमारा रेडिंग से लिखा होगा ना, डेट कब आया। लिस्ट ऑफ साइटेशन नया बना। कभी डिसीजन 75% जमा करना।
Yes.
Well, my first point is this, Lordship. When the arbitral tribunal passed an order award, Lordship, that was challenged by the respondent writ petitioner lordship by filing a writ application. And no, the writ petitioner respondent lordship did not approach the honorable district judge by filing any application or appeal under section 34 or 37 of the Arbitration Act, lordship. Here, lordship, so there was a alternative remedy. That remedy was not exhausted by the respondent writ petitioner lordship, directly came to this honorable court and filed the petition. And the petitioner appeared lordship and prayed that the section, my second submission is this lordship, section 19 of the MSME Act provides that no appeal, application, any petition shall be filed without deposit of 75% of the decretal amount. Lordship, will you please to peruse the section 19. There is a total prohibition of filing any appeal or writ or any application law.
Writ also.
Huh?
Writ also.
Yes.
Writ.
Petition is mentioned. Petition means that includes writ also.
Doesn't mean writ, sir.
No, there are Supreme Court decision also on this point, Lordship. Lordship, will you please to peruse the section 19. Application for setting aside any decree, award or order. No application for setting aside any decree, award or other order made either by the council itself or by the institution or center providing alternative dispute resolution services to which a reference is made by the council shall be entertained by any court unless the applicant, not being a supplier, has deposited with it 75% of the amount in terms of the decree.
Have you raised this
award.
objection? Sir, have you raised this objection before the learned single judge?
Yes, we have filed affidavit in opposition. We raised this question.
Where is the, from this order, it has not been reflected that any such objection was raised?
Lordship,
From the improved order, there is no.
that has not been mentioned by the learned single judge. That has not been mentioned, but I personally, I argued before the learned single judge. I raised this question. In my affidavit in opposition, Lordship, this ground has been clearly taken. In spite of that, page 46.
Yes.
Lordship, will you please to come to page 46 of the memo appeal, where I had taken the specific plea. Page 46. Para J, that the writ petitioner has illegally attempted to invoke the writ jurisdiction of this honorable court with ulterior motive and design to avoid the payment of 75% deposit, which the writ petitioner is required to pay as a condition precedent to challenge the decision passed by the respondent number 2. And orally I had submitted, Lordship, before the learned single judge Lordship, that until and unless the 75% amount is deposited, the writ.
Mr. Roy.
Yes.
Without going into the technicalities, you please satisfy us how this MASME can entertain this reference under section 18 when the civil court has already decided against you, sir?
No,
What is
Lordship.
the jurisdiction of
Yes,
the
yes,
MSME?
Lordship.
Did your suit for this claim, your claim in the suit has already been rejected. First appeal also rejected, I thought second appeal also rejected, then what remains?
No, what happened, Lordship? this Interest on Delayed Payment Act came into force with effect from 23rd of September 1992 as per the ordinance formulated by the President of India. Here, Lordship, and when this act came, Lordship, there was a simple provision under section, Lordship, may please to pay to the Interest on Delayed Payment Act 1993.
You just give us the answer that your money suit was already dismissed by the civil court.
Yes, I am giving that answer, Lordship.
Yes.
Because Lordship, may please to pay with section 6 of the Interest Delayed Payment Act 1993. The amount due from a buyer together with the amount of interest calculated in accordance with the provisions of section 4 and 5 shall be recoverable by the supplier from the buyer by way of a suit or other proceeding under any law for the timing in force. This was the provision. There was no provision for approaching the Industrial Felicitation Council, and there was no Industrial Felicitation Council constituted in Assam before 99. So when Lordship, thereafter on 10/8/98, this provisions of the Interest on Delayed Payment Act was amended, Lordship, incorporating that your Lordship will find section 7A.
Yeah.
Earlier in the original Act, Lordship, this provision was not there.
Fine.
It was incorporated at the bottom of the book, your Lordship will find that is this amendment was done on 10/8/98, Lordship. 10/8/98, Lordship. So when when the suit was filed, Lordship, the this amended provision came into force, Lordship.
Suit was filed in the year 2000.
Suit was filed in the year 2000, Lordship. 2000, money suit was filed in the year 2000. And this amendment, Lordship, when the suit was filed, this amendment is of 1998. So, Lordship, my submission is this: the Honorable Trial Court, who was trying the money suit, it was the duty of the court to remand the matter or transfer the matter to the Industrial Felicitation Council.
Which court?
Civil court, trial court, in money suit.
But sir, if they're not done and that judgment has been affirmed up to this court, what remains in the
Lordship,
matter?
this matter has been decided by the apex court. I have come with the judgment that after.
Then you should have challenged that order of the trial, the civil court.
No, I had challenged by filing the RFA.
RFA, that has been dismissed.
That was it also, that court also did not send the matter to the Industrial Felicitation
Then
because.
you should have filed it to the, approach the Supreme Court, sir.
Lordship, may we please to consider at that time, only Industrial Felicitation Council was constituted by the government of Assam in February 99, Lordship. February 99. And there is also just,
Suit was dismissed on which date?
pardon, my lord,
The money suit was rejected on which date?
money suit was rejected, Lordship.
In the year 2007.
Yes, most probably, yes, 2007.
So how this industry specialization concept?
Lordship, so after the amendment of this act of 1993, the civil court has no jurisdiction to try the suit, Lordship. The only option was.
That you should have raised in this appeal itself or RFA or whatever the ground.
But court should also take the judicial notice of the
Yeah,
enactment or the
exactly.
amendment, Lordship.
Take
It is
this,
my humble submission, this, my lord.
So
It
that
is the.
amounts to review that order.
Lordship, here the Supreme Court has laid down the law that when after amendment, Lordship, if the civil court does not have the jurisdiction, if any judgment is passed by the civil court, that will be a nullity in the eye of law. So if a judgment is a nullity in the eye of Lordship, that's why I subsequently approached the Industrial Felicitation Council, which passed the award. Lordship, may please to peruse the apex court judgment on this point. Lordship. Judgment निकाला Check law, pehla first judgment. First lordship, I like to place.
Just.
सीरियल इससे बनाना चाहिए.
हाँ, number one में पहला तो तुम ले ली, number two में
It cut off is clear. All good. 2004. In the 48. Okay, secure.
three ले ली.
Hmm.
Number three ले ली.
No.
Yes.
My lord, first, regarding the deposit of 75% amount, lordship. Lordship, may you please to peruse the first judgment, lordship, para 3, 4, and 11. This is a Supreme Court decision, 2012 6 SCC 345.
Certainly, that is there. But sir, you have not raised this point before the learned single judge, and if you have raised and are not dealt with. We are not in
Lordship,
we have to suggest you, but ultimately you should have filed a review petition before the learned single judge.
Lordship, I had submitted orally also.
Sir, already,
Lordship,
in it is not reflected from this order, but at
Lordship,
least you should file a review petition before the
Lordship,
learned single judge.
if-
That I have raised this point and you have not dealt with it.
Lordship, in my affidavit on opposition, I have placed before your Lordship that
Sir,
I have
you,
taken.
you might have said before us, but what about the learned single judge order? We can't ignore that order, sir. That is the proceedings of the court and we have to take it as you have not raised this point. And if you have raised, the proper course is for you to file a review petition before the learned single judge. Why he has not dealt with it?
No, I raised the question or not, that is a that is immaterial, that is
Sir,
my
that is
submission,
material since
because Lordship.
That is material
No,
because
as because Lordship, my
if you
humble.
have not raised, then it would be treated that you
No,
have waived
my
it.
lord, my humble submission in this, as per the section of 19 of the, there is a total prohibition of filing any application, appeal, or any other petition, Lordship, without, there is a precondition to deposit 75% along with the filing of memo appeal.
Yes.
Memo appeal, Lordship. So when there is a total prohibition under section 19 for filing any writ or petition or anything, any form of petition, Lordship, the writ petition ought not to have been registered, Lordship. And
Yes.
it could not be decided, Lordship, without during when the matter was argued before the learned single judge, I had specifically placed, I had argued personally that matter,
Yes.
Lordship. But that was not reflected in the impugned order. So what the council will do if the honorable judge did not reflect in the order sheet? But my affidavit in opposition is very clear. It was also the duty of the learned single judge to peruse the affidavit in opposition, Lordship. This shows that the learned single judge did not gone through my affidavit in opposition and pass the order unilaterally. Apart from that, Lordship, there is, your Lordship will recollect that SBP and Company versus Patel Engineering Limited Company. That is a judgment of the Constitutional Bench by 7 judges,
Yes.
which clearly stated that in no circumstances against the award of arbiter counsel, the writ or any application will be entertained. Only remedy is to file application under section 34 of the Arbitration Act or 37, Lordship. That remedy has not been exhausted. In the writ petition, the respondent writ petitioner has stated in last para that there is no alternative remedy. Equally efficacious alternative remedy. Now, your Lordship may be pleased to peruse the Patel Engineering Judgment, Lordship.
Sir, first of all, you were referring which those judgments that 75% amount has not been deposited and therefore writ petition cannot be entertained.
Yes, Lordship.
Which are those judgments on which you are placing reliance on this point?
Yes, that was the Lordship Apex Court decision, 2012-6 345. 345, Lordship. That is the judgment number 1. No? First judgment, Lordship. Page number 2.
Yes.
Apart from that, there is also for deposit of 75% amount, Lordship is mandatory. Our own High Court has our own judgment, which is the judgment of 2002 1 GLR.
So this judgment, Good Year India Limited, first judgment is this.
Yes.
Another is
Another is our own High Court judgment, Lordship, flag number 7.
7.
Flag number 7. This is a division bench judgment, Lordship. Lordship may come to para 11 and 12.
Yes.
Para 11, adverting to the argument of the council, council of the decree holder that no appeal shall be entertained until and unless 75% of the decretal amount is deposited, as is envisaged by section 7 of the act. This is the old act. of the Act, we are of the considered view that the judgment debtor was bound to make deposit of 75% of the dictatorial amount within the ambit of the provisions of Section 7 of the Act. The word shall in Section 7 of the Act denotes that it is the mandatory requirement of the law that 75% of the dictatorial account has got to be deposited before filing of the appeal. This citation was also placed before the learned single judge, but there is no whisper in the judgment. So the Supreme Court decision is also in the same line, Lordship, and our Honorary Court division based judgment is. So already I have submitted, Lordship, when there is a total prohibition of filing of appeal against the award of the Industrial Facilitation Council, the writ ought not to have been entertained, Lordship. So it was without jurisdiction, Lordship, violating the provisions of Section 7 of the Interest Delayed Payment Act, and subsequently the Section 19 of the MSME Act law. Now, your Lordship, may please to come to the this 2005 Lordship 8 HCC, that is SVP and Company Lordship Patel Engineering, which is a constitutional bench judgment consisting of 7 judges of the apex court. Flag number 2.
Yes.
Lordship, para 44 and 45. Lordship got it?
Yeah.
Para 44. It has seen that some high courts have proceeded on the basis of that any order passed by the arbitral tribunal during arbitration would be capable of being challenged under Article 226 or 227 of the Constitution of India. We see no warrant for such an approach. Section 37 makes certain orders of the arbitral tribunal appellable. Under Section 34, the aggrieved party has an avenue for ventilating his grievances against the award, including in any in-between orders that might have been passed by the arbitral tribunal acting under Section 16 of the Act. The party aggrieved by an order of the arbitral tribunal unless has a right of appeal under Section 37 of the has to wait until the award is passed by the tribunal is after all the creature of a contract between arises. The Chief Justice may constitute it based on the contract between the based on contract between the parties, but what would not alter the status of the agreement. We therefore disapprove the stand adopted by some capable of being corrected by the High Court under Article 226 or 227 of the Constitution of India. Such an intervention by the High Court.
That is there, once no writ court can entertain such writ petition under Article 220 against the arbitral one.
Yes, yes. Here, your Lordship, the respondent petitioner did not file any application under Section 34 or 37 before the Honorable District Judge.
Yes, that's.
And there was an alternative remedy available. And what Lordship, in spite of this judgment, also I had placed before the learned single judge. But there is no whisper law. What I can do, Lordship, when there is a constitutional bench judgment consisting of 7 judges of the apex court law, and this is the leading judgment of the apex court on this matter law. Now, your Lordship, may please to come to this flag number 3. They also apex court judgment, Secure Industries Limited versus Godrej Bioseed, para 13 and 14. Flag number 3.
Yeah. Yes, the next.
3.
Yeah.
para 13 and 14.
Yes.
I'm coming. Right line. Para 13, Lordship. This brings to us the ground on which the High Court stayed the proceeding before the council, namely the alleged failure of the appellant to serve notice under section 21 of the Act of 1996. The point was not raised before the High Court all by the respondent number 1. This was candidly stated by the learned counsel for the respondent number 1. Our attention has not drawn to any other legal proceeding which requires a notice to give permission to the commencing proceeding apart from section 21 of the Act 1996 Act. Whether the notice was a notice under section 21, by giving the notice under section 21 is to be construed as a precondition for the exercise of the jurisdiction by the council, or the question which the council will have to decide. This debate should not be a ground for the High Court interfering with the council jurisdiction and staying proceeding before it. Para 14. To sum up, the High Court urged in staying proceedings before the council, it has no jurisdiction to do so. Having regard to our conclusion, we have agreed by the parties the appeal before the High Court really become infructuous. This is not relevant. So para 13 and 14 are relevant, Lordship. So the writ is not maintainable in any circumstance, Lordship, against any award order passed by the Industrial Facilitation Council. Only remedy lies under section 34 or 37 of the Act of 1996, that is Arbitration Act. Next citation. Next citation is Lordship flag number 4.
Yeah.
This citation is Lordship 2001-6 SSC, page 369, para 6.
Yes.
Yes, para 6, last, I think last page. The Act has been enacted with a view to provide a special procedure for recovery of the debts due to the banks and the financial institutions. There is a hierarchy of appeal provided in the Act, namely filing of appeal under section 20, and this fast track procedure cannot be allowed to derail either by taking recourse to the proceeding under Article 226 or and 227 of the Constitution by filing a civil suit, which is expressly barred, even though a provision under a cannot expressly out the jurisdiction of the court under Article 226 or 227 of the Constitution. Nevertheless, when there is an alternative remedy available, judicial prudence demands that the court refrain from exercising a jurisdiction under the said constitutional provision. And this was a case where the High Court should not have entertained the petition under Article 227 of the Constitution of India and should not have directed the respondent to take recourse to the appeal mechanism provided by the Act. So already I had submitted before your Lordship, when the Interest on Delayed Payment Act was amended, Your Honor, in 1998, and when the civil suit was pending, Lordship, which was filed in 2000, it was the duty of the learned trial court to send the matter to the Industrial Facilitation Council as per the provisions of Section 7 A, B, C of the Interest on Delayed Payment Act. That has not been done. So that was without jurisdiction, Your Honor. But whether learned trial court pass a decree in favor of the plaintiff or dismiss the suit, Lordship, that is, but the court must have the jurisdiction to try the suit. After amendment of the Act of 1993, the civil court has no power, Lordship. Only option is to approach. That's why I have submitted before your Lordship that when the suit was dismissed, when the RFA was dismissed, both the Honorable Court had no jurisdiction to decide the matter. Then the next citation is Lordship. Here, Lordship, when the writ was filed, I have annexed the copy of the written affidavit. The respondent is a company, Lordship. No board resolution was filed or annexed with the writ petition, Lordship, to prove that the person who swayed the affidavit in support of the writ petition, Lordship, has been authorized by the board of directors to file the writ petition, Lordship. Your Lordship, may please to peruse the how in what a careless manner the affidavit has been filed in support of the writ petition. Page 25, writ petition, they start from page 25.
Yes.
Affidavit, your Lordship, there is no, 40, page 40, Lordship. Here, page 40, Lordship.
Yes.
Yes, Lordship, this affidavit has been sworn in support of the writ petition by Balraj Singh, son of Associate. I am the Deputy General Manager of the petitioner corporation. I am well acquainted with the facts and circumstances of the case and authorized to swear this affidavit on behalf of the corporation. So, Lordship, the respondent is a company, corporation, Lordship. Before initiating any legal proceeding, Lordship, it is mandatory under the Companies Act. At that time, the 1956 Companies Act was in force to pass a resolution authorizing Sri Balraj Singh to file the writ petition, which was not done. And in this, in support of my contention, Lordship, I'd like to place before your Lordship FX court decision. 2011-11 SCC flag number 5. No, court will write. Second half.
Yes, F2.
Public. Lordship, I was, the first of I was placing the judgment of the apex court that when a
Without
board of directors of,
authorization, without any authorization.
Without.
yes, Lordship. And in the present case, which I am going to place, Lordship, in that judgment, Lordship, election,
Like 5.
flag 5, Lordship.
Yeah.
Flag 5, this is the apex court decision reported in 2011-11 SSC 524. Here, Lordship, at page para 14, Lordship. In our view, the judgment under challenge is liable to be set aside because the respondent has not produced any evidence to prove that Sri Ashok K. Shukla was appointed as the director of the company and a resolution was passed by the board of directors of the company to file suit against the appellant and authorize Sri Ashok K. Shukla to do so. The letter of authority issued by Sri Raj K. Shukla, who described himself as the chief executive officer of the company, was nothing but a scrap of paper. A scrap of paper. And the no resolution was passed by the board of directors delegating the powers to Sri Shukla to authorize another person to file suit on behalf of the company. Here in the present case, Lordship, in the writ petition, the deponent who sweared the affidavit in support of the writ petition simply stated that he is such and such official. There is no whisper in the entire writ petition that any resolution was passed by the board of directors authorizing the person who sweared the affidavit, Lordship, that is Balraj Singh, to represent the company, Lordship. So whole, Lordship, the averments made in the writ petition will be inadmissible, Lordship. The next citation.
Back here.
Lordship, our High Court judgment is there, Lordship. regarding that if any irregularities was committed by the Industrial Felicitation Council in passing the award lottery, in that case, the lordship, the matter can be remanded to the Felicitation Council, but not by the through writ petition, but by while deciding the application under section 34 or 37 of the Arbitration Act, lordship. That judgment your lordship will find flat 7. Huh? 6 lords.
Yes.
Lordship, may I please to come to internal page 6, lordship, which will prove that the Industrial Council was constituted on 12/2/99, lordship. Para 9, internal page 6.
Yes.
Para 9, lordship, in exercise the power conferred under section 7A of the Act 93, an expected above notification was issued by the government of Assam, constituting and setting up a industry felicitation council by outlining the main function of the council in para 2 of the said notification. The notification dated 12/2/99 and so and so published in the Assam Gazette on so and so so and so. So before 99, lordship, there was no Industrial Felicitation Council, lordship. And lordship, here the
Yes.
lordship may come to internal page 11, lordship.
Yes.
Last para.
Yeah.
Lordship may come to last para. The Industrial Felicitation Council Assam, the respondent number 4 is directed to consider the dispute between the parties afresh in terms of the notification dated so and so as extracted above, and in the light of the findings recorded by the court as above, it is made clear that the above exercise shall be completed as expediently possible within a period of 4 months from the date of receipt of certified copy of this order. Here in the present writ petition, lordship, the only complaint of the writ petitioner respondent is this, lordship, certain provisions of the Arbitration and Conciliation Act were not followed by the Industrial Arbitration Council, lordship. So these are my submissions, lordship, and deposit of 75, without deposit of 75% of the award, no writ or appeal or any application even under section 34 or 37 of the Arbitration and Conciliation Act 1996 can be entertained.
Yes.
May I please your lordship?
I fail to understand why my friend Mr. Roy is basically harping on the Arbitration Act. There's nowhere there is an award in the whole record. There is no arbitration proceeding anywhere. Only few minutes of the Facilitation Council has been annexed. That is the minutes of the meeting. That cannot be termed as arbitration award.
Yes.
So the Honorable Single Judge has rightly pointed out in para 18, in para 13 of Lordship judgment, in page 108 of the writ appeal.
Yes.
The letter 5/4/18 and the extract of the meeting of 12/3/18 clearly show that no conciliation was effected between the parties with regard to the dispute raised by the respondent number 3. Further, very fact that the direction has been issued with council during the meeting in the office of the Commissioner Industries Commerce, Assam clearly shows that the issue raised by the respondent number 3 with regard to the non-payment of his alleged dues has not been decided by way of arbitration anywhere. Under the provisions of the Arbitration and Conciliation Act, it is a settled law that where a power is given to a certain thing in a certain way, they must be done in that way and not in other way. So this my friend has enough opportunity in the lower court, in the other forum, appellate court, or writ petition. He could have exercised the option for arbitration, going to the arbitration. No way. Nothing. Not 89 of the CPC, he has given enough power. He could have referred it to the commercial court or anywhere for arbitration. So at this stage, how the word arbitration comes? Without any arbitrator appointed by any competent board. There can be. Now, it is a forum choosing. Forum choosing, and the Supreme Court has in Chetak Construction Limited, Om Prakash, said that we certainly cannot approve any attempt on part of any litigant to go forum shopping. A litigant cannot be permitted to choice. So at the initial stage, he has opted for civil suit. First, he lost empathy. This honorable court, he lost. Then he chose that, well, better I should go to the council. Somehow or other, I can get something that is good. Then against that, we moved the honorable court. Look, what is it? Then the lordship rightly observed that you cannot do this. Forum choosing is not big. So forum shopping has been, and also doctrine of election. Doctrine of election is applicable because at the initial stage, he opted for a civil suit instead of any arbitration or any conciliation anywhere else, long back. Now at this belated stage, he moved this honorable court on retail. I respectfully submit that I shouldn't go in more than that. That it is a big case that is appeal, make kindly be dismissed.
Lordship, here there is no question of forum choosing or forum shopping, Lordship, because when the interest in delayed payment act 93 came into force, Lordship. Initially, already I have submitted before Lordship that there was no provision for the constitution of or approaching the Industrial Facilitation Council. Act was amended only on 10/8/98, Lordship. And there, but Industrial Council was constituted in February 99, Lordship. And thereafter, Lordship, the judgment was delivered by the learned trial court in money suit in 2007, Lordship, when the trial court has no jurisdiction, Lordship, to decide the dispute between the parties.
Still, you have not answered the question that the trial court has rightly, wrongly, whatever it may be, has rejected your money suit. You preferred appeal against that. That appeal has also been dismissed. You have not further challenged that order before any forum, including the Supreme Court, that has attained finality, wherein your claim was considered and rejected on merits, that no dues are there. How to come out with that?
Lordship, I already have submitted before Lordship, that when the judgment was passed by the learned trial court, as well as by in the RFA, Lordship, the civil courts had no jurisdiction, Lordship, no power to decide the dispute, Lordship. So the judgment is a nullity in the eye of law, passed by the trial court or also passed in the RFA, Lord.
Sir.
Lordship, Muhammad Lordship, me please to record one judgment, Lordship, 2005 7 SCC at 791, Lordship, where the apex court had let down the law. If a court does not have the jurisdiction to try the suit or appeal, Lordship, even then, if the judgment is passed, that is a nullity in the law, and it will have
2005,
2005 7 SCC 791.
79.
791. Parties are Lordship. Parties are Lordship. Harshad Chiman Lal Modi. Harshad Chiman Lal Modi versus DLF Universal. Harshad Chiman Lal Modi versus DLF Universal.
Yes, order reserved.
Like
Photocopy of the.
Item 11.
My lord, before the learned single jars, all these materials were not there.
Not there.
Yes. So learned single jars proceeded on a different basis.
But
My lord, there the learned single judge has said, depending upon the outcome of the criminal case, action perhaps can be taken by the authority. Now, in view of the new developments, my lord, I understand the Public Service Commission has come up with an chart.
the state and the public service, both of them come with the chart and from.
I think five
whatever
will
the
be,
exercise
five will go.
The 5 or 6, the entire selection has to.
No, my lord, I don't think, no, my lord, Lordship will clearly see, even if, let us assume there were some wrongdoing, even then Supreme Court says, if any appointment can be saved, that could be saved.
Sir,
I'm relying on the judgment, my lord.
In fact, appointments have still not been given.
No, appointment has been made, only posting was not required to be
So
given.
it may be, sir, ultimately it has not culminated in the posting. And the
No,
thing is, sir,
but that way, my lord, merely
looking
because
to-
somebody's name
looking
appears
to
in
the-
select list also, any crystallized right may not have accrued.
it's better what we are proposing that cancel all these selections and allow the state government to conduct a new selection, allowing the persons who are the writ petitioners or the respondents to appear in that, granting them age relaxation along with the new eligible candidates. They'll again consider it. And
No, my lord, my humble submission would be, I'm relying on the judgment.
Yeah.
2003 7 SCC 285, where Supreme Court has said, if any appointment can be saved, that should be saved. And the Public Service Commission has come up with that.
But sir, the thing is, only it is not a question of 5% from 10% or whatever the number of persons.
What?
The manner in which they have selected, they have reduced the number of almost every candidate. They have also increased the number of 7 or 8 other candidates. And not once, twice, thrice.
No, my lord, what I find from the chart now prepared by the Public Service Commission is, the end result is this.
So, result is this, but
Yes.
the manner in which they're done, you just go through this.
No, I have seen it. I had the occasion to go through it, my lord, in an earlier round of litigation.
Earlier round of litigation in every
No,
case.
even, sorry, in this round of litigation only.
Only
this
at
matter was heard for-
on earlier date of hearing.
Yes.
Yes. Sir, in this every time and twice or thrice for some candidates, twice or thrice they have changed the numbers and without there being any justification for that. So that,
So I think, my lord, my only humble submission is, I think Public Service Commission has taken note of all the
you just see this,
aberrations.
this 17, this Shahzad Begum appellant.
Yes.
She was awarded, I don't know, in column number 11, whether it was 21, 16 or 17. It seems pehle 21 diya, then it was made to 16, then cut ke fir 17 kar diya. Uska, the grand total 73, then 71 and then 69. And so on, sir. Just after that, this Sadanand Sekia, 28 to 25 was changed without nothing, and 70 to 73. That is absolutely, it seems in almost every candidates, they have reduced or increased, and most of them
The
reduced.
beneficiary, on one occasion, this list was given to us also.
Yeah.
So what we find is, out of the selected candidates,
I mean,
for
one case-
example,
in one case,
number one,
experience, initially they gave one number, thereafter +1 and 2 numbers.
I agree, Milord, it should not be done. But Naina Bhuya, the person who got the first nomination, her mark was decreased.
And sir, this, the one of the candidate, his marks were enhanced 68 to 75, straight away.
No, I think that is Masjidul Islam.
No, sir, this is Deep
Hirajyoti, no.
Deep Jyoti Sharma.
Ah,
Deep Jyoti Sharma. Earlier it was 68 and then 75.
Deep Jyoti Sharma, it was increased.
General bearing 29 marks out of 30.
No, Milord, what I'm trying to say is, in the column that is initial marks, that is without any change. That is the actual mark. Kindly only take note of that, Milord. Eventually, Lordship will pass the order. It's only by humble submission. I think the column initial mark, that is correct.
Ultimately, once there is a doubt about the assessment which they have made in the manner in which they have given the marks, even though in relation to some persons,
No,
the question mark
Milord,
is there that.
Milord, this Deep Jyoti Sharma should be out because her mark has increased. So that's why I'm saying, at least initial marks is correct. That is nobody's case that it is not correct. So final marks after scrutiny, that is something doubtful. So let's go by the initial marks. Then whosoever's appointment can be saved should be saved, and whosoever's can't be saved should not be saved.
So once it is, there is a doubt in the manner in which they have done this, then certainly, and coupled with the fact that these
My lord,
the persons are in jail
my lord,
for
all
doing
respect-
all these irregularities.
My lord, with all respect, I'll submit right from that Punjab Public Service Commission case,
Yeah.
boy Indrajit Khelon, Joginder Pal, in all these cases, Supreme Court has always said, please save the appointments which can be saved. That's my humble submission, my lord. I'm relying on that judgment. That 2003 7 SCC 285,
Yeah.
Union of India versus Rajesh PU. Here, I got judgment to be on it.
Mr. Additional Advocate General, what is the view of the state government looking to this, whether they are in favor of this, keeping this recruitment as it is or what?
Sometimes state will appoint once the lease is final, if the lottery approves of the lease, we will.
Whatever it may be, looking to all these,
That is why we have not appointed till now. And there was
another thing, now what is your view? What is your view? That looking to this, still you are interested in keeping the appointment intact or shunting out some of the persons whose marks are doubtful or whatever it may be, and otherwise.
Those whose marks have been inflated, they should be.
Whether this is what the view of the state government in view of this irregularities which you have pointed out yourself.
No, I have not pointed.
Sir, the court has directed you to point out.
In my individual capacity, I have done that.
So you have done that, then you should apprise the.
Now that the matter is pending before lordship, we can.
That's why only looking to this, if even though if the state government is interested to keep these persons or what, to give validity to validate this selection process.
in view of what has come up in the records produced by them, we cannot say that it's a valid treatment.
Then what is your view? Ultimately, what do you want to do? At least clarify your stand.
Then madam, we file an appeal. Otherwise, I can on my own take a statement.
No, you can't take on your own. That's why only. Okay. We'll obtain the view of Parliament, but then only we'll proceed further.
In fact, my lord, there are some 3F appointees who are the beneficiary in the whole process. In fact, my lord, if these selectees would have been appointed, some 3F appointees would have to make the rule. There are officers in the department who are saving. Anyway, my lord, this is.
This writ appeal is filed by the appellant being agreed with the order dated 25/9/2018. Passed by the learned single judge in writ petition number 853 of 2017. The appellant in the writ petition has questioned the process of recruitment conducted by the Assam Public Service Commission on the post of district malaria officer pursuant to the advertisement dated 15/12/2012. Stop. The appellant has contended before the learned single judge that the APSC has prepared the final select list only on the basis of marks obtained by the candidates in the Viva Voce test, ignoring their scores in the written test. And written test, it was also contended that the selection process itself was vitiated by corrupt practice in the instance of one of the member of the interview board and on similar allegations. Stop. The learned single judge has dismissed the writ petition by holding that the rules permits selection solely on the basis of Viva Voce test. And so far as regarding the allegation of corrupt practices are concerned, the appellant has failed to prove the said allegation. Stop. But during the pendency of the present appeal, this court directed the APSC to produce the record along with the record. Stop. When the record was produced, this court has perused the evaluation sheets and observed that there have been rampant cuttings and overwritings in the manner of awarding marks to the candidates. Stop. This court has further observed that there are various other discrepancies on which no comments can be offered, as the criminal case in relation to the selection in question is still under investigation. Stop. The record with the photo state copy of record produced by the APC was provided to Mr. D. Majumdar, Additional Advocate General Assam, with the direction to prepare a summary thereof for assistance of the court regarding the irregularities committed in the selection process. Full stop. Mr. Majumdar, Additional Advocate General, Assam, and the counsel for the APSC has submitted a summary before this court indicating, highlighting the irregularities committed during the selection process. Full stop. The Additional Advocate General has admitted that the irregularities in the selection process, the irregularities committed in the election, selection process are of substantial nature. And therefore, he seeks some time to complete his instructions, whether the state government is still interested in protecting the said selection process or not. Stop. He placed some time to complete his instructions. When?
3 weeks time.
What 3 weeks? 1 week is enough.
My one submission subject to lawsuit.
1 week is enough.
My one submission I'd like to make. And ultimately, with the facts that have come up now, what is necessary is for adjudication of this honorable court that whether the entire selection is vitiated or not. This your lordship will decide, my lord.
Prima facie, we are of the
My lord.
opinion.
So once
that-
your lordship,
So you make your submission that
My
since the entire selection is not vitiated or is vitiated,
Partially
what is the
vitiated.
opinion of the state government? That's all. We are seeking only
My-
this.
my-
Why are you shying in that?
no, my lord, my submission is selection has
Don't-
been made by them.
Now, don't fire the shot on the shoulder of the court.
Matter
Take a
is,
decision of yours.
matter is before your
Come
lordship.
forward, okay? If you are not interested, say it. What's the problem in that? Okay, no, we are, since the irregularities are in relation to some of the candidates, we want to protect this selection process. We'll consider that. What's the problem? This one,
Let it be a couple of weeks, man.
Yeah.
Couple of weeks.
no. Not couple of. 26th June. Come with 26th June.
Item 14.
May I please your lordship? My lord, before starting, my lord, yesterday, my lord, I had a call, my lord, from one of the engaged counsel, P. Mahanta, appearing for respondent number 1. He says, my lord, that he has been newly engaged and therefore he will be sitting some time today. And so therefore I did not prepare.
Where is Mr. Mohanto?
Now Mohanto is not available, my lord, his junior is there.
Yeah,
On behalf of Mr. P.
yes.
His lordship, we are seeking a short accommodation in the matter of newly engaged.
The order is in favor of the respondent. Still you are seeking time.
Because of some communication gap, my lord. Otherwise, I was supposed to appear.
The request of non-concept of the list of the summer vacation. Respondent.
That may be fixed, my lord.
You take the date from the registry after summer vacation.
I'm so deeply obliged.
Item 15.
May it please the lordship. Lordship, as per the order of this honorable court, 13th of February 2023, the respondents were supposed to file an affidavit and produce origin records, lordship. Till now, we have not received any affidavit.
Where is the need of that?
Yes, lordship. Lordship, I'm ready with the matter, lordship.
Yes.
Yes, lordship, I'll start the matter.
Yes, who is appearing for the other side? Yeah, you are appearing.
I'll be appearing.
Yes. You ready?
My lord, the original record is, or original record has been received, my lord. Original record has been received, my lord.
You have already filed your affidavit?
No, my lord.
Why? On this 13/2/2023, Mr. M. Das, government advocate, submits that he received the original report and raised some time to file an affidavit.
My lord, I'll do it, my lord.
This is not the hearing category matter. This is the hearing category matter.
Let it be after vacation, my lord. In the meantime, I'll file my affidavit.
When he was dismissed from the service,
Lordship, he was removed from service on 10th of September 2014, Lordship.
14, and he approached the court
Lordship, after 6 years, 10 months, Lordship, because he was suffering from neurological disorder, Lordship.
without filing any departmental appeal against the
Lordship,
board order.
Lordship, he filed reply to the show cause notice, Lordship.
You filed
Reply to the show cause notices. 2 notices were issued to him, Lordship. 2 show cause notices.
against the dismissal order, no departmental appeal was filed.
No, Lordship, because
Why?
Lordship, he was suffering from severe neurological disorder, Lordship. He was not in a statement.
Who prevented him to file a departmental appeal? If he can approach the court, he can very well.
Lordship,
file
he approached the court much later because Lordship, he was suffering from neurological disorder. He was not in a physical as well as a mental state to approach the court, Lordship. Firstly, he took care of his health. Later, he approached his court, Lordship.
Is there any documentary evidence that you were suffering from this nervous breakdown and anything else?
Indian prescription, my lord.
Prescription medical report is there, and Lordship, he was not suffering from mental disorder. He was suffering from physical neurological nerve problem, Lordship. Neurologia,
And
Lordship.
he was earlier worked as?
Lordship, he was an unarmed branch constable, and he worked
If he is not physically fit, how he can be retained as a constable in the police force?
Lordship, I get it, Lordship. Now
Now
he
he's
must have
okay.
now he must have superannuated by this time, Lordship. But my case is that, sir, Lordship, he's worked for more than 30, he's worked for around 37 years, Lordship. If Lordship, if he's reinstated, or Lordship, if his removal order is removed, Lordship, then he'll be eligible for family pension, Lordship. After working for 37 years, Lordship, due to some neurological disorder, he could not communicate to the department. That doesn't, Lordship. And Lordship, the writ petition was dismissed only on one ground, Lordship, delay in lashes.
It's better.
Yes.
Delay and lashes are always better.
Yes, Lordship, but delay in lashes, the single judge relied upon one judge in Tarsim Singh, Lordship, delay in lashes, but the Tarsim Singh, Lordship, talks about 3 conditions of delay in lashes, Lordship. In the third condition, where a third party needs to be, no, if a third party is aggrieved, then delay in lashes is not applicable. And Lordship, in this case, Lordship, we fall under the third category, Lordship.
Very hard case. Okay, file your counter.
Deeply observed.
Item 18. May I please your lordship? 2015, 2015, 2015, 4. Is 334. Let's see. 2015, 4 SCP. 334. Develop Punjab versus Tropik Machine. Reliving the last page 351. Yeah, relevant 345. Hmm. Yes. My lord, actually, I do not like to waste valuable time of this highest judicial forum. If Rafi Maji case is applicable to me squarely, then the matter ends there.
Which case?
In the state of Punjab versus Rafi.
Yeah.
Because I'm a lower division estate, I retired as a upper division estate, grade T, and grade C employee. So my respectful submission before your lordship is that this case is squarely applicable to this Supreme Court judgment, which, my lord, I'm really sorry that in the judgment, Rafiq Maji was referred to. But the speaking part, which the Supreme Court has settled, and the last part of judgment in para 18, that has not been quoted. That has not been referred to by the Honorable Single Judge. I do not know why, but my respect.
Para 18.
My lord.
Read para 18.
It is. It is not possible to postulate all situations of hardship which would govern employee of is to recovery, so far as recovery is concerned, where payment have been mistakenly made by the employer in excess of the entitlement. Be that as it may, based on this decision referred to herein above, we may, as a ready reference, summarize the following few situations wherein recoveries by the employer would be impossible in law. It is not permissible. So the recovery from the employee belonging to class 3. My lord, I am class 3 employee. Then, lordship, recovery from the retired employee. You have retired me. so or employees who are due to retire within 1 year of the order of recovery. So recovery, so these two are very much applicable to in my situation. If it is acceptable to your lordship, then I shouldn't travel to.
Kindly see page 102. Page 102 of the paper book, your
Milord. Yes, Milord, yes.
Is this a letter written by you?
Milord, yes.
What remains then?
Milord, that is.
You yourselves have admitted I have overstayed knowingly, unknowingly. Please pardon me. I am ready to pay. You deduct my whatever the salary I have received.
That
Once
is,
your admission
Milord,
is there, then you can't change this.
Milord, that is the whole crux of the matter. Suppose assuming this letter is written by
It
me.
was not a case where the government has wrongly or mistakenly paid you something. It was a case of misrepresentation where you were ought to retire in the year 2009, but you produced some other certificate instead
No,
of.
No,
Sir, that-
Milord, this may I submit? What is,
Where was the occasion for you to write this letter, sir?
Milord, why?
Where was the
That is,
occasion for you?
that I am coming to this. Because once it is an admission, suppose it is an admission under the Evidence Act, under 17, section 17. But it is the direction of the Supreme Court. You see what are the circumstances. When my admission, one I have admitted, but admission must be clear.
So that's why only what I am asking, where was the occasion for you to write this letter?
That is, my lord, my explanation, would your lordship may kindly be travel, if your lordship my reply, because I am retiring, you have asked me, they go. You have applied for VRS, you need not come anymore. But you give me the retired benefit because I am a cancer patient. You have not given me the retired benefit.
That is actually.
My lord, the circumstances must be noted before coming to a conclusion. The circumstances that an employee who is not getting his retired benefit, the quantum of pain only could be realized by a retired person. What are the pains? Leaving my young children?
Things are not paid.
Yes.
In fact, when you came to know that some inquiry is going on and they'll take some criminal action against me, then you wrote a letter and said, "Okay, please pardon me.
No.
I've done this mistake. Please let me."
What is the material? What is the material
that
that
they have not taken any action against you, do you turn back and file this petition?
no? You say, where is the inquiry? My lord, some documents should be there. There is no inquiry at all.
Sir, this letter, whether you disclose this fact that I have written to them that please deduct my overstay amount, whether you have disclosed this fact before?
No, because
why you not disclose this fact in the writ petition?
because, my lord, I will come. What is the letter? What is my letter? Contents of my letter.
Yeah. Yes. Read your contents of your letter.
Yeah. Only in it is in Assamese, Lord.
Sir, I have this 102.
English only
English version, it is translation is correct.
Milord.
Translation is correct,
Yes.
then it's okay.
Yes. Knowingly or unknowingly.
I have the honor.
Yes. Yes. I have the honor that the SEBA authorities has sent me HSLT certificate as I have said that I have been received my last so and so. Why I have written, my lord, that it is to be seen because they have not given me retirement. They asked me, you give me your paper. Service book is there. They are the custodian of my service book.
I have the honor to inform you that SEBA authority has sent my HSLC certificate as I said, which have been received by me last week and enclosed herewith, as per the said certificate, I should have been retired from service on 31st of October 2009, but knowingly or unknowingly, overstayed in service for 2 years, 10 months, for which I beg your pardon.
Yes.
I hereby inform you, sir, that about so and so overdrawn, 13 lakhs something was overdrawn. That is from November 2009 to August 2000. I earnestly request you to release the provisional pension from September 2012 till date by deducting the said overdrawn amount from my DCRG, unutilized leave salary and provisional pension after calculating the same for the period so and so. A due and drawn statement has been appended herein for your kind information.
Yes.
Again, you have appended some statement also.
Why I have written it? Because you have not released my retired benefit. You see, my lord, they have written a letter to the Seva authorities for confirming about the nature of the certificate given by me. Then Seva authority said that you sent back the original certificate to us so that we can complete the inquiry. But the respondent failed to do so. They have not allowed the Seva authorities to complete the inquiry.
It's a very hard case, and certainly such persons who have submitted a false certificate.
No.
Or regarding, yes, sir, it was the Seva authorities has also confirmed that it's a false certificate of the year 1970 when 162 students only have passed. The roll number could not have been there.
Your lordship is correct in that up to date. But my question is that what is my entry point? That is, the Supreme Court has said repeatedly in various cases that the entry point, what is your date of, what is your age?
Yes.
Yeah,
Okay, then we'll do one thing.
Yeah.
We'll order for an inquiry
Yeah.
that who has submitted
Yes.
the false certificate,
Yeah.
and suddenly that certificate is produced by you only.
Only with reference to the service.
Whatever it may be, that certificate, that 1970 certificate belonging to you is a forged one or not. Ask the police authorities to conduct the inquiry, and if any illegality is found, then certainly a case would be registered against you.
My lord, I'll gracefully agree because, my lord, entry point I have given all the same. But while a person is drowning, you give me the benefit, you write under pressure, there is a certain judgment.
It was the pressure.
Huh?
What
Enough
pressure?
pressure.
What
Enough
pressure?
Pressure means you give me your certificate. You are the custodian of my service book. Why do you press me?
Very unfortunate, sir, since they have let off you because no criminal proceedings were initiated against you, then you turned back and said, okay, give me all this also. What is this? Have some grace.
My lord, one may take a second.
Yeah.
So the page 104.
Yeah, 104. Yeah.
This is a letter
Hmm.
written by Secretary Board of Education
Yes.
pertaining to the verification of my certificate, which I had submitted to the Deputy Commission. My lord, in this point, I must submit before Lordship. It's a non-traverse principle hit by because the respondent about Deputy Commissioner has not appeared, not filed any affidavit in this case. Why?
Yes.
Neither the government nor the Deputy Commissioner has filed an affidavit in this case.
Yes.
What? Please, I'll give you this hand. Who is the Treasury officer? I am not concerned. My concern is against the impugned order of the Deputy Commission. He has never appeared before the court nor filed any affidavit. So it's a principle of non-traverse, definitely hit this case. Now, this letter, contents of the letter, your lordship will With reference to the subject above, I have the honor to state that there were 162 number of candidates self-election 1970 from this center. The roll number so-and-so particular 279, therefore roll number Manik Sharma is doubtful. I request you kindly send the original pass certificate and the admit card of the candidate for verification necessary inquiry. So inquiry was not concluded. Why you have not given me a chance? Can you kill me from the Cooper's case to this? Hundreds of cases that reasonable opportunity has not been given to me before punishing me in this way, recovery.
Something else?
Only can I refer to few of the judgment or?
No,
No, not
nothing.
necessarily this
There's
one.
no requirement.
So this will, inquiry will be, let there be an inquiry.
We'll pass a note. Close for all. Yes.
Item 21 and 22.
Lordship, 22 may be taken first. Let the senior argue, Lordship, then my job will be easy. Lord.
Yes. Two questions, my lord, arisen in this appeal, my lord. Firstly, my lord, whether the order dated 31/10/2016 would be operating as a res judicata for deciding the subsequent writ petition. And secondly, whether the interim order passed in the writ petition, when the subsequently writ petition is still itself dismissed or disposed of, have the effect, and the party are entitled to be relegated to the position prior to the interim order that was passed. Now here the order dated 31/10/2016 that was passed solely on the ground that the Act of 2011 under which parties were litigating, that has been declared ultra vires. It was not decided on merit. And the interim order was passed to the effect that the service of the provincialization of the present appellant is stayed. And on dismissal of the writ petition, so that interim order also merged with the final order, so that also goes. I should have been relegated back to the position where, my lord, whereby I was, my lord, enjoying the benefit of provincialization. Now here, my lord, the 14/8/2014, my service was provincialized. I have joined in the service. I have been receiving my salaries, etc. Then the writ petition came to be filed by the respondent number 4 and 5. And there is an stay, or there is an order whereby the order impugn was stayed. And pursuant to that order, the government has passed an order withdrawing the order of provincialization. Now, subsequently, this writ petition has been dismissed on the ground that the act is no longer in force. I have submitted my representation that I should be restored, my position should be restored back. And in the meantime, the judgment by which the Act of 2011 was declared ultra vires. That was reviewed. It said that until the next new act is formulated by the government, the status quo of the persons who were appointed will remain. Now 2017 Act come into force, whereby all the persons whose services were provincialized under the old Act 2011, these have been retained. They have been preserved. Under these circumstances, I have submitted my representation before the authority to review the order by which the provincialization, my provincialization has been withdrawn. That having not been done, I have preferred a writ petition. And by the impugn judgment, Honorable Court has held, as because the earlier round of litigation, the order of dismissal is still in force. So therefore, it cannot be, no relief can be granted in this present report. That is the precise case. Yes. That is the facts may not be much necessary on these things, my lord. The law is, my lord, Ketna decisions, my lord, are there, my lord, the apex code that when the interim order passed and ultimately the writ petition or the proceeding has been withdrawn or dismissed, in that case, parties has to be restored back to the original position. They'll get that, my lord. Yes. And secondly, my lord, due to change of law, 2000 Act has gone. There was no law at that time. Then subsequently 17 has come. With the change of law, there cannot be a res judicata under the law on which the judgment was not passed. Yes. May I submit those judgment. A list of book.
Somebody is appearing on behalf of the private respondents. Yeah.
There is a termination of-
There is a,
That is 2017, the Assam Education Provincialization of Service, Teachers and Reorganization of Education Institutions. Act
so the thing is that their services were provincialized in the year 2014.
14.
And in the year 2016 or some the year 2016, that order was revoked.
2014 itself.
So in the 2014 itself, that order was revoked on account of stay order passed by this
Yes.
court
Yes.
in writ petition.
Yes.
Ultimately, that writ petition came to be dismissed.
Right.
Without deciding on merits.
Right.
Then certainly those 2014 orders, provincialization has to be restored.
Lordship is
What's the position?
So that's what, my lord, because we are claiming seniority over them, they are claiming seniority
That's
over us.
another thing. Then once their services are restored, then you can very well approach the tribunal for that purpose.
That's what I may say. Initially I said, my lord, that it should be referred to the tribunal.
The
Because
tribunal, but first of all, they have to restore their position of this provincialization.
but while granting interim order in my favor, I'm fully satisfied that learned single just that point of time. That order is at page 59, Lordship may see.
Yeah.
But may I read, my lord? The order dated 17/9/2014, page 59, my lord.
Yeah.
Heard Mr. J. Leonard Counsel for the parties issue notice reliable on 14/11/2014 and Mr. S. Saikia Leonard Senior Standing Counsel, Secondary Education Department has accepted notices on behalf of respondent number 1, 2, and 4. No formal notices are recalled for. So far, the respondent number 3, who is now represented by Mr. Bhagwati Leonard, recommended the petitioners will, however, take steps in respect of so and so. Though the respondent number 7 has filed a caveat, there is no representation from him. Seeing the impugned order dated 1/8/2014 issued by the respondent number 1 on comparative reading of the impugned order of at Annexure 12 to the writ petition and the appointment letters to the petitioners as found page number 36 and 42 respectively of the writ petition and the particulars prepared by the headmaster of the school concerned, which are at page 52, 54, and 56 of the writ petition. I am of the view that a prima facie case has been made out by the petitioners. However, a state for the learned Senior Standing Counsel, Secondary Education Department is granted time till the returnable date to obtain instruction. However, till the returnable date, the service of the respondent number 7/8 shall not be provincialized. A copy of this order be supplied to the learned Senior Standing Counsel, Secondary Education. So in view of this stay order, my lord, on 6th October 2014, they have, my lord, with the order has been withdrawn by the provincialization.
But sir, ultimately this writ petition came to be dismissed.
Yes, that's correct.
Then this order has to be revived. 2014 order. Provincialization order has to be revived.
But Lordship, I say that, my lord, that order which was they have got the provincialization, that order, my lord, is by the government, my lord, because government has decided the issue. So that is, my lord, absolutely wrong order, my lord.
Absolutely wrong order. Challenge it before the tribunal.
Instead of challenging, my lord, matter can be referred to the tribunal, my lord, because
No. You should, the thing should be clear. Their services were provincialized. You were aggrieved by that. You filed the writ petition wherein the stay order was granted. Ultimately, writ petition dismissed, stay also gone. They were supposed to reinstate them. And if you are aggrieved by that provincialization, you can very well approach the tribunal.
But
this will be the simple approach. Yes, Mr. Counsel for the state.
Admittedly, this is a seniority dispute between the private petitioner and a private respondent. And after deciding the seniority, benefit of provincialization was given to the writ appellant. And they have filed a writ petition, and where the stay was granted and that was withdrawn. Thereafter, my lord, government did not take any step to revive it
Should have taken the steps.
because, my lord,
Anything else? This is what the case of
That
both the-
is one, these are- One more, my lord, just one line, my lord, in addition. The writ petition by which they challenged my provincialization order as well as the seniority. After dismissal of that writ petition, they did not take any steps either for review or appeal or revival of the proceeding, nothing.
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 They're not. Yes, Mr.
I leave it to your lordship.
Order is the.
And lordship may grant liberty, my lord.
Yeah, that, if you are aggrieved by that provincialization or what, you are, you have liberty to challenge the same in accordance with law, no problem. That.
That's all.